This video contains excerpts from an online workshop that the US-Asia Law Institute held in June 2020. The workshop participants were legal professionals or scholars from mainland China, Taiwan, and Japan, who were already broadly familiar with the United States criminal procedure and evidence rules. The presenters were experienced judges, defense counsel, former prosecutors, and law professors. The workshops were designed and led by US-Asia Law Institute Senior Research Scholar Ira Belkin, a former federal prosecutor.
So there were no really regular rules around the admission of expert witness testimony before the Fry case in 1927. It had been a hodgepodge of different types of decisions. And then there was a challenge to the admissibility of a very, very early iteration of what today would be called the polygraph test or a lie detector test. And the challenge was in the DC Court of Appeals, which is still today, a very influential court. And what happened in Fry is that the court took a look at this whiz-bang technology that was being touted as an ability to tell if somebody was lying. And the court was deeply skeptical of this technology, the ability to tell if somebody was lying or not. And what it found was, so there's a reason that I highlighted the psychological and physiological authorities there, because that'll become important in a minute. And this is an interpretation of this 1927 case in 2006 by the New York State High Court. Fry, this first decision, became a landmark decision. It's not a Supreme Court case, but it became the standard for most states for the introduction of expert witness testimony. And what happened between 1927 and 2006 is that courts around the country interpreted the Fry decision to kind of come up with some general principles as to applying Fry to either include or exclude scientific testimony. So what the test became known as is the general acceptance test. And what that has a couple of different elements to it. And one was that it was supposed to be novel. In other words, that it would have to be something new. So, for us, at the Innocence Project, where we're concerned about techniques that were once admissible, but have been discredited through the progress of science, you couldn't even really challenge the scientific testimony at issue through Fry because it has to be novel, and these techniques aren't novel anymore, right? So theoretically, you cannot challenge them. So there are also general acceptance means that the court itself was not charged with basically learning the science. What the idea became was that judges, they're not scientists, they're not mathematicians, they're not really in a great position to judge scientific validity and reliability issues. What they say was it's the scientific community that is in the position to judge whether the science is valid or reliable. So what they said is that if it's a new technique, you look to the scientific community and see whether or not within that community it's gained general acceptance. Right. And so, in other words, it could be a minority point of view would not be admissible. Right. So because it hadn't gained general acceptance yet. So the idea was that courts would do essentially a nose counting, they would define the community, which we'll talk about in 1 second. And to say is this a generally accepted forensic or scientific technique? Now, how that community became defined, the relevant scientific community, and the reason that I chose this line, because this is the New York court, it says the scientific community generally. Now, that's kind of a generous use of that phrase, because that means basically any scientist right? But most courts called it the relevant scientific community. And, that makes sense. But how you define the relevant community is basically outcome determinative as to whether or not it's going to be admissible, right? So because if you define the community, let's take something like fingerprints, right? Fingerprints, if you define the scientific community as fingerprint examiners, the question as to whether or not it's generally accepted within that community is a foregone conclusion, right? They make their living doing fingerprints, right? So of course, they're going to tell you that the science is generally accepted. And they're going to argue that they're the scientific community, that it should be them that is the arbiter. So what that leaves out are people like statisticians, right? And a statistician could tell you, well, you may believe that the fingerprints are unique, right? And particularly latent fingerprints, which only have, partial information. But as a statistician, I can tell you that you don't have the statistical foundation to make that claim, right? That's just your opinion. And that opinion is not valid based on science as we know it today. And that's true with all pattern matching techniques. Even DNA, we assume DNA is unique because we've done sufficiently robust studies that the law of statistics allows us to make that assumption. But even then, you don't say there could never be another one because we don't know that. So the idea that the problem, depending on the way it's interpreted, is that only novel testimony was challengeable, and courts began to look to forensic experts and define the experts themselves as a scientific community. Courts had, for 50 years, and Tucker and I wrote an article that talked about some of this, had defined the relevant scientific community as the bite mark experts, the dentists themselves, right? And they had invented the whole thing. They'd never done any foundational research about it at all, but it was accepted widely. So we have, in strategic litigation in particular, been litigating in courts in states that still have the Frye standard to say that no, the scientific community includes people like cognitive neuroscientists that can talk about bias, statisticians, physicists, you can go on and on with like the different techniques. So we're trying to get more expansive rulings, and Tucker is correct in that the Frye standard is outdated. But you look at the states that still use the Frye standard, it's some of the most populous states in the country. So it's still a very significant standard, sadly, I think in many ways.
It seems like the theory of the court in the Frye case back in the 1920s was that science only moves in one direction, that science only moves in the direction of progress. So when new scientific methods are introduced, they have to go through this vetting process meet this threshold standard. But once a court accepts that branch of science, it doesn't have to examine that anymore, because the theory is scientific progress only moves forward and doesn't review previously accepted scientific conclusions. Is that right?
It's exactly right. And what really the work of the Innocence Project and related, organizations demonstrated, beginning in the late 90s through DNA exonerations, is that all these forensic techniques that had been accepted by courts for a very long time, had passed through the Frye test, were actually not valid. They were getting it wrong. They were falsely convicting people for crimes that they did not commit. So the idea that science can also, I think it still could be considered progress. It's just saying, well, what we knew before, we no longer believe. So there's a recent decision in the New York State Court of Appeals, which in New York is the state, essentially the Supreme Court, the highest court in the state, that we and two other criminal justice reform organizations, we submitted a bunch of briefing and litigated a lot around this issue. And we got a better interpretation of the Frye standard in New York. So, and we also litigated the same issue in Pennsylvania. And now what they're saying, they pointed to things like bite marks and hair comparison evidence and acknowledged that some techniques may not be novel, but are subject to challenge. And they also talked about defining the relevant scientific community as not just the self-interested experts and pointed to the Office of the Chief Medical Examiner in New York City, which is the most influential medical examiner's office in the country, that had been using a statistical tool to analyze tiny amounts of DNA that they had insisted for years that they had internally validated, but was in fact not reliable, not valid, and finally taken offline. But every court in the city and the state had deferred to the OCME, defined them as the community that was in charge of this particular technique, and just never actually examined it. It took a federal court to order the OCME to turn over that data before we learned that, oh, they were wrong, right? So it's really, really important how in FRI jurisdictions, if we don't consider people who don't have any stake in a particular technique, we have to have outside critics, basically. You know what I mean? Is that people who are going to give it a fair read and a critical examination.
Fry was a case from the 1920s. Rule 702, as we said, which ultimately codified the admissibility in the rules surrounding expert testimony, didn't get to us until the 1990s. If you were to look at Fry, if we're to read Fry in a vacuum, Fry seems like not a bad decision. Kind of makes sense. Yeah, we want to admit expert testimony only if the general scientific community agrees that it's legitimate. That sounds good on the surface. That sounds like a rule that makes some sense. But after we get to Dalbert in the 1990s, then I think we can really begin to see the point that Ira brought up and that Chris elaborated on, which is, wait a minute. Science is not a static field. It's dynamic. There are developments constantly within the field. And the general acceptance test that Fry has another side to it. And that side can be limiting, can be problematic, can be almost anti-science. And that's what we'll get to.
Every state has a different interpretation of its own evidentiary rules. You know, so there are nuances in every state to basically every evidentiary rule. It's state Supreme Courts that interpret the evidence. Usually, I mean, there are some that are done by, study groups. Every state is a little bit different. So New York standard, I put that up because it was available. It was an interpretation, a more modern interpretation of Fry. It changed it in the sense, the reason that I used it was two things, is that I thought that it was important to show that there were some states that say that it's the scientific community generally, and that was one time that the court had said that. There were other times where it said the relevant community, but that was a more recent pronouncement. So we used that particular case a lot when we were talking about that to make the argument that it's not the practitioners themselves that define the community. When it's generally accepted as reliable it's kind of vague, what reliability in science, basically means that it can be repeated, right? And that two experts, analyzing the same evidence will come to the same conclusions, under the same circumstances. So that produces reliable results, right? And so that extra results is an important piece of language, because if it's generally accepted as reliable, doesn't really it can mean a lot of different things.
This gets incredibly complex very fast, because as I understand the Parker case, and I don't practice in New York, I know of it. The ultimate conclusion, opinion that the expert was offering was really not the issue. There was general agreement that these chemicals could cause these problems. Seemed like that was something that experts could and had testified about over and over again in cases dealing with, I think it was benzene, exposure to gas. But there was a threshold question, which was, well, how much gas or benzene, if I'm correct, was this plaintiff actually exposed to? So in other words, before we get to the ultimate opinion, which is that this is dangerous, you can get cancer from exposure to benzene, we need to know whether or not and how much this plaintiff had been exposed to benzene. That was and the plaintiffs, if I recall, either didn't present any or didn't present enough evidence of the plaintiff's exposure. So at least as I hear your question, or at least think about it, that's sort of my point, that this becomes complicated. Yes, it's generally the case that experts have been allowed to talk about the dangers of benzene, but we're not just going to necessarily admit this particular expert to talk about the dangers of benzene unless this expert or other witnesses can first demonstrate that the plaintiff had been exposed for some period of time, right, that would have made it dangerous. Even though the Frye decision was a 1920s decision, every state, including the states that have continued with the Frye standard, have developed the standard over the last 7 decades. So in some sense, to say that it's the same Frye standard that came out of the DC courts is not exactly accurate. States have used that standard and applied it to developing scientific disciplines in order to, for lack of a better description, keep it up to date.
A really good example of this, if you look at Florida or you look at Georgia, and their standards for expert witness testimony have evolved over the last 10 years. And really, if you think about whose interests are served by better science being used in court, right? It's like, and this is true with so many things. If you follow the money, you're probably going to get your answer. And so when you have large corporations that are routinely sued by plaintiffs' corporations sometimes for good reasons, sometimes for, less good reasons, is that what those corporations want is to attack the small guy, right? The plaintiff's experts are often depicted as the small guy, right? Who have like this one expert that's going to say that that this big bad chemical company caused the birth defects of my child. I don't have the resources that Dow Pharmaceutical, which was the defendant in the Dauber case, has to fight that off. So it benefits large people that are sued a lot to exclude evidence that suggests that they're liable for whatever kind of tort is being charged, right? So there was an industry push to enhance the rules of evidence because there was this spike in civil litigation in the 70s, 80s in particular, that a lot of major corporations got bankrupt by plaintiffs' attorneys that were filing lawsuits around the country. If you look at like the silicone breast implants, or that kind of thing, that a lot of like bad science was used that brought down companies that were actually not committing torts. So that standard, if you look at Georgia had been controlled by Democrats who tend to that's a complicated history in Georgia around this, but the idea is that Democrats tend to favor the small guy, the plaintiff's lawyers, right? You know what I mean? And not the corporations. So when a Republican was elected to the Georgia governorship for the first time in a century, first thing that the corporate bar, you know what I mean, like basically started lobbying for was to change the evidentiary standard from this incredibly lax standard they have in Georgia to bring in Daubert to protect corporate defendants and corporate interests from the lawsuits. And so this happens, and then people aren't usually thinking about the impact that it has in criminal law, right? Because it's the same standard, you know, and on both sides, and like the money always leads than the criminal side. In Georgia, just to tell you a story that's really outrageous and that we're doing a lot, and it kind of speaks volumes about what we're talking about here in terms of the justice aspect of expert witness testimony, is that when the Georgia Republican, Sonny Perdue, who's now the Interior Secretary, was elected governor, they started this movement to change the rule to Daubert. But Georgia had this thing that was even more permissible than Fry before that. And the prosecutors came in and they said, fine, you can change the expert witness rule for civil, for the money matters, but we like our standard over here for criminal matters. And so as a result, Georgia has two rules, right? They have one for civil and they have one for criminal. And so in my mind, the reason that some states have it and some states don't is largely based on corporate America and less about some of the other issues that we're talking about. You could find people that would disagree with me, certainly, but I think that there's a real element of that.
I just want to add there some foundational issues that I'm sure you are aware of, but sometimes it's easy to forget that in the United States, because of our federal system, on some issues, every state gets to decide their own rules. You know, we don't have a national system the way China does, or a unitary system. So how to define crimes and how to define evidence is left up to each state. We don't have to have a uniform rule. So that means states have the ability to adopt whatever rule they think is appropriate. And then, so we don't necessarily have uniformity. But the other thing I want to mention, it's sort of in the background of our discussion, but we haven't talked about it directly yet, is how powerful these rules are. As Chris mentioned, if you make the threshold very high, that would exclude certain types of evidence. The jury would never get to hear that evidence. And again, our evidence rules are mostly written for civil and criminal cases, and in general, Georgia is the exception. We wouldn't think that the standards for admissibility on expert testimony should be different for criminal cases or civil cases. The real issue is how do you define a rule that allows reliable scientific evidence in, but excludes unreliable scientific evidence. That should be the same for criminal and civil. But because the interests are different, it's possible, although it's exceptional, to have different standards. You know, I think your question kind of assumes that everyone will just adopt the best rule, however you define the best rule. But our system allows different people to define whatever the best rule is differently, depending on the circumstance.